Welcome to this morning's webinar. My name is Megan Tucker. I am one of the Workplace Relations Advisors for Jobs Australia, and I'm here with Adrian Cucci from Marsh. So we're going to have a two-session webinar today, and at the end we'll do some questions at the end. So I'll present my piece first, then Adrian can come in and present his, and we'll go from there. So my part is talking about COVID-19 vaccinations and the impact on workplace relations. So this has to be one of the most contentious issues that we've been dealing with over the past at least 12 to 18 months in regards to the whole pandemic situation and workplace relations. So the mandate of vaccinations in the workplace covers a large scope of areas of law that we need to take into consideration. So these are our relevant state-based laws, such as our public health orders, and you're going to find that they differ from one state to another. Occupational health and safety laws. Now, we do have model laws in some states, but some states will have their own individual laws that are applicable, and that's especially in regards to our risk assessments and our consultation processes that we need to follow. We then also have to take into account equal opportunity law, human rights law when it comes to medical exemptions, and some religious beliefs as well. Then we have our industrial law, so that's consultation requirements under applicable industrial instruments and relevant privacy laws that we need to take into account in regards to collection of personal information. So, number one question that we've probably been receiving for the past five to 6 months is, can I request or require, direct, demand my employees to be vaccinated? So yes, employees can be required to be vaccinated in situations where there is a public health order or directive that requires the employee to be vaccinated. The requirement is governed under applicable industrial instruments, or would be reasonable for the employer to give such direction on a case-by-case basis. So in regards to public health orders, and we'll go through it a little bit more in depth to come, but that's really two areas that we need to look at is, what is the public health order? Is it currently in place? Who is it applicable to? Are you governed by it? The date of operation and the date of expiry, and if there's any fines applicable. So they're important things that we'll need to look out for. So when I like to advise on the mandating of vaccinations in the workplace, this is the thought process that we generally will go through in regards to if an individualized organisation has the right to indeed mandate the vaccine in their workplace. So we've got two steps here. Is there a current public health order in place? If there is, yes. So our public health orders are our underpinning area of law when it comes to the mandate of vaccination. So basically, under a public health order, your state can direct that your employee cannot work in a certain industry or role on the basis of their vaccination status. So once the vaccination is mandated to a specific work or industry, we then need to run our consultation process. So that's basically advising the staff of what the public health order is, how that's going to impact on their employment, and then seeking any information such as exemptions. We're then going to pick out those identified employees and they're advised to speak with their GP if they have any concerns about their vaccination status or where they're in lines. If the employee is then not vaccinated by the date applicable or the time that is allocated under that public health order, then the employee is stood down from that date going forward. So if your organisation is not covered by a public health order, there's a couple of additional steps you're going to need to run. So the consultation is run with all staff in regards to implementing a mandatory workplace vaccination requirement, not under a public health order. The organisation would then need to undertake both a risk assessment done on an individualised basis for the roles of the employee and how they come into direct contact with others or the outside world, or what is their main task of their role. Then the workplace policy is put together for workplace vaccinations, and that has to all be presented to staff as a part of the consultation process. Then again, identified employees are advised to speak with their GP if they have concerns about their vaccine status or relevant government information is provided to them. And then the identified staff is stood down if they're unvaccinated at the end of that. So in regards to public health orders, there are orders that are given by the Chief Health Officer. They have the additional powers that are allocated under them each state in regards to the necessary process to stop the spread of COVID-19. There are currently orders or directions in every state and territory of Australia, and these can change actually pretty quickly. So we'll see states like New South Wales and Victoria that have had public health orders pulled and then changed, amended, new dates added, and that's really in reflection to the current ongoing crisis and how they are working through that. So public health orders will have a date of operation and an end date, and depending if another order is given past that time as well. They then provide the scope which can be implied by the organisation as how that employee can work. So if it's a situation that if an employee is in disability, they cannot provide any further support ongoing past X date. They'll also put directive dates of when each vaccination must be held by for the employee to continue to work. So some orders may have the employee must have the vaccination by first vaccination by 1 December and then second by X date. And then after that, following X date, if the employee is not fully vaccinated, they can no longer work. Now, public health orders must be complied by both the employer and the employee, and some orders may have a fines applicable to both the organisation and the employee for working unvaccinated during a public health order in place. Both the legalities over public health orders have been tested in New South Wales and recently in Victoria, and they have all both failed at their challenge. So medical exemptions. So if we've got an employee that provides to us a medical exemption, this must be supplied in the format of an approved medical contraindication form, and each state or territory has their own contraindication form that must be filled out by the employee's practitioner, and there are a certain list of practitioners that can issue a contraindication exemption. So these are the few contraindications that can be listed. A lot of them are due to a history of anaphylaxis or a serious reaction to the current vaccine, and some other forms of medical conditions as well. Now, once an employee supplies the employer with a medical exemption, they then are governed under our relevant human rights laws. So our equal opportunity laws, also privacy needs to be taken into account. And this is a big question we get asked by our organisations. If you do have a staff member that has a medical exemption, and they give that information to you in privacy, you can't then tell other staff members that X staff has a medical exemption unless that consent is given to share that information. So it gets a bit tricky if you've got a fully vaccinated employee who refuses to work with non-vaccinated persons. We just want to be careful not to take any adverse action against the employee with a medical exemption, because we can then be seen to be discriminating employee, and there can also be a basis of general protections in that regards. So medical contraindications generally are only exempt for a period of 6 months, and after that point they require a review ongoing. Okay, so once we stand down our employees, what type of leave can be accessed by staff under a stand down? So an employee that stood down because they refuse to be vaccinated can be given access to their accrued leave entitlements, such as annual leave or long service leave. An employee cannot access personal leave during a period for which they are stood down for non-vaccination. Okay, so the most important process is getting the consultation right. So a good consultation process will require the organisation to share with the employees on how the vaccination changes are going to affect them, when they're going to come into place, relevant risk assessments to the individual employees or group of employees, allowing for a period of time for staff to provide feedback to the changes. And then from there, taking the employees' views into account when implementing that change. So when we are looking at introducing a mandatory vaccination policy in the workplace, there's not covered under a scope of a public health order, we really want to have our vaccination policy in place or in draft form, and also any relevant risk assessments to give to the employees at the time of consultation. So when we start looking into the relevant case law that we've seen come about because of the mandate, it really is highlighting the importance of consultation, and that's what they are reviewing when it comes to policies, dismissals, implementations being just. So the first leading case that we really had in regards to COVID vaccinations was the SPC case. So they were the first Australian business to, outside of our health industry or our frontline industry, to mandate COVID-19 vaccinations for all staffs and visitors in the workplace. So the arguments raised by the union were only in respect to the consultation process of the rollout of the vaccination policy and the process for which the consultation has occurred. So in regards to unions' interventions when it comes to mandatory vaccinations, it has been in bipartisan with the employers, only because I guess they're not in the industry of making health decisions. We're just really there to make sure that the consultation process is run correctly with staff. So concerns were lodged to WorkSafe, and they investigated it and found that the consultation was done correctly with staff, and there was no evidence that SPC had indeed breached any rules in regards to its consultation process. And then from there, they did bring in their policy of mandatory vaccination across all staff and visitors in that workplace. SPC also at the time provided additional information or additional benefits to its staff in order for them to get vaccinations. So it was additional days off to get vaccinated. If there was an adverse action, they required to take some leave, then they did give them additional personal days. Now, when it comes to adverse action to reactions to vaccines, Adrian will go further into that for you in the following presentation. Now, supporting your employees to get vaccinated is really important. So like I said, with the SPC case, allowing staff paid time off to get vaccinated. So not directing that they are required to access personal leave for that time to go get vaccinated. offering them any support mechanisms in order for them to get vaccinated in line with your organisation's policy if you are going to mandate it. Directing staff have concerns with being vaccinated to their treating GP. At the end of the day, we're employers. We are not medical practitioners. So in regards to making suggestions to employees about what is the best vaccine for them, that really has to be done by their medical practitioner in regards to their options. But what we can do is to make sure that the employees have access to reliable and up-to-date information about the effectiveness of vaccinations available from the Department of Health. And the number one thing I can say is leading by example. A lot of our CEOs and HR managers have set the pathway by being the first ones off the bat to get vaccinated if they are looking at implementing a mandatory workplace policy. And that has caused for a greater collegiate take on the mandate of vaccinations. So the tricky question that comes to us is, can I terminate a staff member for non-vaccination? Now, before I answer this question, I just want to be a little bit cautious in our approach of the fact that we are still awaiting a number of test cases to come through in regards to unfair dismissals and non-vaccination of employees. So when we do give advice in regards to termination of staff members for refusal to be vaccinated, we advise organisations that without there being reliable test cases really behind us, that there is still a risk to the organisation for termination. It's not doable, but we just want to prevent risk as much as policy. So an employee can only be terminated if it is lawful and reasonable to do so. The reasonability is a question of fact, which can vary between workplace and workers. So when we're looking at this question, we're really looking at the individual employee for which we possibly could be terminating. And that is taking regards to their risk assessment. What is the current outbreak of COVID in the area? Is there high case numbers? That those types of requirements need to be satisfied to say that the requirement to be vaccinated is reasonable in the circumstances. Now, the Fair Work Ombudsman has given certain directions in regards to types of employees that they would possibly deem to be reasonable to direct. But again, a lot of their wording is using possible, reasonable, language in regards to termination on that basis. So in regards to actually following through, it would have to be done through a disciplinary process. That's still going to be required to be followed. So advising our staff of they're not being vaccinated, the reasons behind the direction to be vaccinated. And then from there, we would be actually following down the lines of refusal to follow a lawful directive versus an employee's flat out refusal to be vaccinated. But again, a cautious approach should be undertaken for the basis of termination for non-vaccination. So in regards to the Ombudsman's instructions, what they've really done is they have defined what tiered workers would most likely have that reasonable requirement to be vaccinated. So your tier 1 workers are people who work with interactions with people who do have an increased risk of being infected with COVID. So they are, for example, their hotel quarantine or border control. And then after that, we have our tier 2 workers. So these are employees who come into contact with particularly vulnerable people and to the impacts of COVID. So that could be aged care, our disability services, frontline homeless services. So all of these could be under the tier 2 industry of workers. Tier 3 is where there's an interaction or likely interaction between employees and other people, such as customers or other people of the public in the normal course of their employment. And then we have our tier 4 workers. So that's where employees have minimal face-to-face interaction as a part of their normal role or their employment duties. So for example, if you're operating under a hybrid system and your employees only come into the office 1 day a week and they work separated, segregated, not together, then it may not be reasonable to direct that individual staff member to be vaccinated on the facts. But it really comes down to what type of industry or organisation is in, what is the mode of operation of that individual employee. Obviously, our public health order overrides a reasonable argument because there is no wriggle room in regards to walking outside of the public health orders in place. Now, in regards to reasonable lawful directions, there was the Good Start early learning case in 2021. So the employee was a educator at Good Start Early Learning Centre. And then in April 2020, Good Start introduced a policy to mandate the flu vaccination for all staff. The employee objected, stating that there was a number of medical grounds that she had had, such as adverse reactions to prior vaccinations. I think there was an argument of being celiac and having a sensitive immune system. The employee was stood down after that time and then finally terminated in August 2020 due to failing to be vaccinated and meeting the inherent requirements of the role. So the Commission found that the workplace policy in itself was lawful and reasonable, and that was looking at the risk to the students and the outbreak of influenza, and that the employee had not actually provided evidence of a medical exemption to the employee. So they hadn't provided a valid medical exemption. They had merely stated that they had those adverse reactions. So the Commission ruled that the employee's refusal to be vaccinated was deemed to be a refusal of lawful direction. Although the vaccination was not an inherent requirement of the role of this employee, they deemed that the failure to comply with the lawful direction was a valid reason for dismissal. So that really negates that argument of the inherent requirements of the role and an employee's failure to follow a lawful direction. But that direction indeed itself must be lawful and reasonable. So it still comes back to the same argument. So the things that we really need to take away in regards to looking at implementing a mandatory vaccination policy in the workplace is consultation. So like those cases, a lot of the questions that are answerable is what consultation that we are running with our staff. And that is having our open and transparent conversations with our staff, running any form of surveys about what is our vaccination rate in the workplace. You must have a workplace policy in place in regards to mandating a workplace vaccination mandate. So that's really going to step out what is the vaccination that's being mandated, what is the process, what is the requirement on staff, when is this policy coming into place. If you're not covered by a medical exemption, a public health order, an organisation may make its own reasons in regards to acceptable medical exemptions. Unlike a public health order where you do have contraindications and specific evidence required, an organisation may make allocations on their own medical evidence, but a contraindication exemption form is really the correct form of evidence that should be accepted. We must maintain privacy when it comes to the information of our vaccinated staff members. It's very important. So even if it's coming to the requirement from the employee to show their employer their vaccination record, that information only needs to be cited by the employer for the process of checking off that the employee is indeed vaccinated, and their certificate of vaccination needs to be removed or deleted by the organisation. And also taking into account if that information is required to be passed on to a third party, you do require consent from your individual employee for that information to be passed on. Now, in regards to our workplace policies, I would heavily suggest that there is clauses that are implemented in regards to how privacy is going to be dealt with in the workplace, because if we do breach it, it is governed by privacy laws for certain organisations. Information on mandatory vaccinations is forever moving, evolving, and it's moving fast. So we are really looking for the major test case to run, which is going to be BHP. And that is really looking at their consultation process and the right to mandate it for all staff. So I do believe that is set down sometime for November to be heard, but we'll wait and see. But each individual state has their own arguments at the moment, and it is a contentious issue in regards to workplace relations. And a lot of our organisations dealing with their employees in regards to mandating in the workplace have come up across some quite emotional reactions in regards to it. So it's just really taking time to get our information together and looking at control mechanisms of keeping your workplace safe. Safe Work Australia does direct under there in regards to their risk assessment that COVID vaccination is only one step in regards to making your workplace safe, and it's not the be all in end all of making everyone safe. So there are still steps in regards to PPE and follow through in regards to keeping a safe workplace. Now, in regards to a safe workplace and occupational health and safety and all that brilliant stuff, I will hand over to Adrian. We'll keep our Q&As to the end after Adrian finishes presenting, and then he and I can both answer any questions you may have.
Thanks, Megan. So as Megan mentioned, my name's Adrian. I work for Marsh and I specialise in workers' compensation. Some of the stuff that I will be talking about will probably overlap with what Megan's already mentioned. There is a bit of overlap, but primarily I'll be talking about COVID and its impact on workers' compensation nationally. So to begin with, I'll talk about COVID-19 safe plans, which I'm sure you're all across. Every workplace essentially needs some type of COVID-19 safe plan in place for their employees. This isn't workers' compensation specific, however, considering they're pretty much used to mitigate illnesses, it will have a flow-on effect to workers' compensation as well. Essentially, the safer your workplace is, the less COVID incidents you'll have and the less claims that will transpire as well. In case someone doesn't know within this webinar what a COVID safe plan must demonstrate, it needs to include actions to help prevent the introduction of COVID-19 in the workplace. It needs to mention the type of PPE required within the workplace, an explanation on how to prepare and respond to a suspected case of COVID-19 in the workplace as well as how to meet and comply with all requirements set out by the government when it comes to COVID-19. So So if you don't have a COVID-19 safe plan in place, I highly suggest you install it. Moving on to OH&S requirements. Again, this isn't really workers' compensation specific. However, these requirements that you put in place will have a flow-on effect to your workers' comp program. Nationally, when it comes to OH&S and OH&S laws, an employer does have a duty of care for its employees. And as I mentioned, it's not just limited to COVID-19. Essentially, to eliminate or minimise any risk of COVID-19 as far as practically possible. Some of the key requirements that all employers should have in place when it comes to COVID-19 should include having some type of incident report form, just to capture any type of COVID-19 related incident. And this could include things such as when the actual case occurred, the symptoms the worker had, etc., etc. Employers must also consult with their workers and HSRs as well, relating to anything COVID-19 related. This would include what type of control measures you've got in place within the workplace, and what sort of communication has been sent out to discuss both COVID-19 control measures and how to comply with national obligations. You've also got to be obviously sticking to the public health advice in your specific jurisdiction when it comes to COVID-19 vaccines. And lastly, there should always be posters and signage and communication around the workplace, just explaining to workers what COVID-19 is all about, the risks associated with COVID-19, and the control measures you've got in place. If you don't have these type of signs or posters around the workplace, I highly suggest you pop them up, and most of the material will be available from your state-based regulators in Safe Work Australia. On to some recommendations on how to actually control COVID-19 within the workplace. You're probably across most of these and they've been well publicised, but I'll run through them anyway. So physical distancing, that should always be introduced where possible to try and stop that transmission. You should be changing of work practices when possible to reduce contact between person to person. Allowing employees to work from home if possible. A lot of the time it's not possible if you're working in a factory or an aged care centre, but if you're working in an office role and there are concerns around COVID-19, working from home is also another option for employers. This one's a bit situation specific, but if there's an outbreak, you can always create workforce bubbles within the workplace. You've got increasing cleaning and disinfection within the workplace as well, especially in high-use areas such as kitchens, avoiding the use of shared equipment such as phones, desks and tools, encouraging everyone in the workplace to practice good hygiene, especially when it comes to using soap and hand sanitizer and stuff like that. This one's quite important, keeping records of workers and visitors when they come to the workplace. In the event that there is an outbreak, you can definitely get onto it as soon as possible and trace where it's come from. And lastly, like I mentioned in the other slide, using PPE equipment as well, especially if you're working in environments such as aged care or disability. In terms of reporting requirements, when it comes to potential case of COVID-19 within your workplace, there are, just to let you know, penalties when it comes to late reporting. So you really want to be across these reporting requirements, or at least have this information somewhere. So if you do have a case in the workplace, you're not reporting late. When it comes to workers' compensation, timeframes are quite black and white, but considering COVID is relatively new in the scheme of things, some of these timeframes are quite vague, and sometimes the timeframe isn't mentioned at all. So in the event that you're unsure about when you need to report this to the regulator or the insurer, I would just report it as soon as possible. I wouldn't wait for a specific time frame. But I'll run through each state regardless. And I've actually got links set up next to each state. So if you do need to log on to the regulator's website or the insurer's website, you've got the link there as well. So starting off with ACT, employers only really need to notify WorkSafe in the ACT of a COVID-19 infection, if there's evidence that it was contracted at the workplace, or if the infected person is hospitalised. Again, there's no time frame specified for ACT, so I'll just notify the regulator as soon as possible. In New South Wales, it's pretty much in line with normal workers' compensation incidents. You really need to be notifying the insurer iCare within 48 hours of a known case of COVID-19 in your workplace. Victoria, it's a bit different. There's no time frame specified. WorkSafe just put out that you need to notify them immediately whenever there's a confirmed case of COVID-19. In Queensland as well, there's no specified time frame. Employees must notify Workplace Health and Safety Queensland as soon as there's a probable case of COVID-19 in the workplace, which has been diagnosed by a medical practitioner as well. Over in SA, similar to New South Wales, you've got 48 hours to notify Safe Work South Australia. Over in Tassie, again, no immediate time frame specified by the regulator, just notify WorkSafe as soon as you're aware that someone's contracted COVID-19 throughout the course of employment. In Western Australia, it's a bit different over there. You need to be notifying WorkSafe WA in the event that death has been caused due to COVID-19 in the workplace. But the medical practitioners over there are actually notifying WA directly. I would probably notify WA Health and WorkSafe WA as soon as you're aware of an incident, but just to let you know, it's primarily the medical practitioners notifying over in that state. And lastly, in the NT, employees must notify WorkSafe of any case arising out of the course of employment in the event that the worker either dies or is hospitalised. On to eligibility now. So just as a general rule, any worker who is injured or contracts some type of illness within the workplace is coverable for lost wages and medical expenses in the event that their claim is approved. Generally speaking, if you've got an injury and illness and it arises out of the course of employment, bearing certain exclusion, the claim should be accepted. And COVID-19 is no different. Each claim is considered an assessment of individual merit. So there's no given that once someone has COVID-19, their claim's going to be approved. But if there's a direct link between the actual diagnosis itself and the workplace, on the balance of probabilities, it's probably going to be accepted. There needs to be a significant contributing factor towards the claim as well. But as I mentioned before, as long as the worker can establish that link between the virus and the workplace, then nationally the claims are getting accepted. The two main eligibility criteria points that all insurers look at is if it arose out of the cause of employment and if you've got that link between the virus and the workplace. So they're the two specific grounds they're looking at. As I said, as long as they're ticked off, then the claim is going to be approved. Moving on to another slide regarding eligibility. As I mentioned, the main contributing factor is a huge factor in the claims being accepted and the known outbreak. But a couple of exclusions that are in place, which would not preclude a worker from having an accepted workover claim, is if there's a shutdown due to COVID-19 and they can't work. So just because the workplace is shut down, and they're not working at the moment, and that's due to COVID-19, it doesn't necessarily mean they'll be able to claim their time loss based on that event. They obviously need to be contracting the virus themselves and having that direct link to the workplace. And that goes with self-isolation as well. So in the event they contract the virus outside of the workplace and they can't work because of it, just because they've got time loss and they're losing wages, doesn't mean that they'll have an accepted workers' compensation claim. It needs to be a direct illness, direct diagnosis, and a link to the workplace. Now going to get into a bit of nitty-gritty when it comes to some of the legislation here. So there's been a bit of activity in New South Wales recently. There was Section 19B of the Workers' Compensation Act of 1987 that was introduced in May last year. And this was essentially introduced at a time where there wasn't a lot known about COVID-19, its transmission and its impact on the workers' compensation scheme. But at the time, it essentially mandated that there was a presumption that the virus was work-related in the event a worker worked for a set employer, and those set employers were primarily around retail, aged care, the health sector, construction, police, emergency, amongst others. And as long as this worker who did lodge a claim within that sector had the virus, there was almost an automatic link between the workplace and the worker, and therefore the claims were being accepted. Things have now changed, or are due to change up in New South Wales. That section of the Act is due to be repealed and dismantled, considering they're now falling in line with the rest of the nation, which is that there needs to be a direct link or a direct outbreak in order to have a workers' compensation claim in New South Wales accepted. It's obviously a bit more fairer for employers, considering a lot of these transmissions probably occurred or did occur outside of the workplace. And it's obviously going to help out with premium spend as well, which is, I think, a good thing for employers and a fairer balance between eligibility and claims being rejected. Moving on to general employer obligations. A lot of these obligations are quite broad, but they also intertwine with COVID-19 as well. So similar to the recommended employer control measures I mentioned in a few slides ago, a lot of these you're probably aware of or are pretty straightforward, but I'll run through them because they are quite important. So when it comes to workers' compensation and COVID-19 specifically, you must be providing a safe work environment for your workers to the extent reasonably practical to do so. You need to be following the directions from the government in regards to COVID-19 as well, including the vaccination mandates. Those posters must be up in the workplaces at all time. You need to be consulting with your workforce regarding your COVID-19 plan and your control measures in place, and make sure it's clearly demonstrated within the workplace. Consultation should also be included as well, just to make sure there's buy-in from the workforce and that they totally understand what your COVID-19 plan is. And lastly, if you do have an accepted workers' compensation claim for COVID-19, just make sure you're participating in return to work planning like you normally would, and offering those pre-injury and suitable duties for your worker to try and get them back to work as fast and as safely as possible. In terms of worker obligations, again, they can be quite broad, but they do intertwine with COVID-19. So workers, like employees, they need to be, I guess, behaving in a reasonable manner and taking reasonable care for both their own health and safety, but the safety of others. And this can be either within the workplace or outside the workplace as well. A lot of have been and continue to work from home, and even though they work from home, it doesn't mean this goes out the window. They need to be looking after the health and safety of themselves and safety of others. Specifically, they need to be cooperating with any policies and procedures that the employer has in place relating to health and safety within the workplace. And this can be specific to COVID-19. So, making sure that they practice good hygiene behaviours and use PPE if they have to, and so forth. When it comes to workers' comp legislation, they also need to be complying with their return to work obligations and general obligations under the Act. Just because they have a potential COVID-19 claim doesn't mean they're exempt. They need to be participating when possible within return to work meetings and complying with the return to work plans. And if this isn't being undertaken, then the insurer does need to put things in place just to make sure they are complying with those obligations. That usually includes measures such as non-compliance and potential alteration of their entitlements. But just to confirm, as long as it's practicable, COVID-19 or the vaccination itself shouldn't preclude the worker from planning for a return to work, for attending meetings and jumping on return to work plans. In terms of claims management and return to work, obviously once that claim is accepted under workers' compensation, and you've got a COVID-19 claim in your hand, you really want to be managing the claims as tightly as possible as an employer to make sure that the claims management is being managed correctly and the workers getting back to work as safely and sustainably as possible. So it is your job to get the worker back to work, whether they've got COVID-19 or not. And if they're in a bubble of isolation, you can still plan for return to work, considering a lot of people can work and interact remotely now. Just make sure your return to work policy is up to date, because if it's out of date, it can cause a few issues. Just some of the things you might want to be mindful as well is that a lot of workers are unsure on what to do when they do come back to work after a bout of being absent or being in lockdown. So reiterating key things in the workplace and how COVID-19 may have impacted their role is quite essential. And keeping in regular contact with your workers, especially injured workers, when they have a claim is critical, because the majority of the time, if you're not communicating with the worker and they're unsure and they're getting a bit anxious, it usually translates into poor return to work results, and suitable duties programs that just aren't going to be successful. So if somebody's off work and they're off work for a long period of time, just make sure you're keeping regular contact with them and keeping them updated about anything COVID related in the workplace, because I guess the most anxious point in a claim or in a return to work program is going to be that initial return to work activity. You also want to make sure that if there is an outbreak or there's a vaccine refusal, that you are continuing to comply with your obligations as an employer. The way the insurer is looking at things is that it's pretty much business as usual in the event that there is an outbreak or there is a vaccine refusal, in terms of completing those workers' compensation 101 actions on any work cover claim. Obviously, there's certain things we need to take into account when it comes to an outbreak or a vaccine refusal, but try to continue to tick those boxes as an employer, as it might come back to bite you if you're not complying with your obligations. Also, it's highly advisable in the event that someone has a claim due to COVID-19, that even though they'll have their medical expenses covered by the insurer, that if you've got it available, that EAP is there for them if they need to speak to someone, especially in the early part of the claim when accessing treatment might be a bit tough. And always draft return to work plans together with your injured worker during a claim, whether it be COVID-19 or not. You're always going to get a lot more buy-in from the injured worker if you're drafting things together and they agree on the return to work program moving forward. And just with pandemic restrictions as well, as I mentioned before, a lot of people are working from home at the moment, and remote working has become definitely the new fashionable thing, considering the pandemic that we're in. So you might want to think of certain things that you can tweak or alter to make sure you're getting your workers back to work in a creative and safe way. And that can be obviously working from home as an option in the event they can't get into the workplace. Onto the COVID-19 vaccinations. Obviously, nationally, there's been a massive rollout of the vaccinations, and there are some people who aren't reacting too well to it due to the administration or the adverse reactions of the COVID-19 vaccine. In the event that there is some type of adverse effects of the vaccination, in some circumstances, they may be able to lodge workers' compensation plans and have them accepted. The majority of the time, they won't be eligible, considering they would have gone off on their own volition and had the vaccine themselves. But there are specific criteria around when adverse reactions to the vaccine will be compensable. So just to run through them specifically, these are the specific things and the specific criteria the insurers will be looking at in the event that they accept a claim for an adverse reaction to the vaccine. So to begin with, the vaccine injury must have arisen out of the course of employment. Employment must be a substantial contributing factor to the vaccine, or at least the main contributing factor to the injury. This one is really important. The employer must have undertaken steps to arrange for its employees to have the COVID-19 vaccine administered. The employer must have at least encouraged or induced employees to get vaccinated in order to obtain the benefit for its business. They must have permitted or released directed employees to have a COVID-19 vaccination during ordinary working hours, and have provided instructions to employees related to the administration of the vaccine. If that criteria, that specific criteria isn't met, then on the balance of probabilities, the claims won't be accepted. So it needs to be a directive from the employer around the COVID-19 vaccine in order for these adverse reactions to be compensable. In terms of the Victorian vaccination mandate, there are varying vaccine mandates in other states as well, but I thought it'd be a bit more time efficient just to concentrate on Victoria. In this presentation, it's been a pretty big issue in Victoria over the past few months, and essentially all authorised workers in Melbourne and regional Victoria needed to have their first vaccine by the 15th of October and the second one by the 26th of November, unless there was some type of medical exemption, in order for those authorised workers to stay within the workplace or return to work after an extended period of leave. There's no issue with an employer enforcing the government mandated vaccine directions. They just need to make sure that they're appropriately engaging with their workforce and making sure that all the relevant information available for their employees are available in the event they have concerns or questions regarding it. In terms of how it specifically impacts new and existing workers' compensation claims, it's a bit tricky because every claim is being considered on its own merits. Every claim is being assessed based on the individual circumstances of that claim. So it's really hard to give you a black and white rule around what's being accepted and what's not being accepted, because at this stage, the regulators and the insurers don't really have anything in place for it, considering it is quite new. So I don't want to give you any fast and hard concrete information during this webinar, but I would be heavily engaging with your work cover agent or insurer in the event that you've got a vaccination mandate impacting either a new or existing claim. So if you've got a worker, for example, that won't come back to work because they haven't been vaccinated and they can't come back to work because of the mandate, I wouldn't automatically say that that worker's going to be not complying with their return to work obligations because they can't come back to work. Everything's going to be assessed on a case-by-case basis, and I'd be engaging with the technical guys and legal guys at the insurer that you're relying to make sure that they're making the right decision in terms of determination on entitlements. As I mentioned, there are varying mandates in other states, but when it comes to Victoria, that's a state of play at the moment. Just quickly, I'm going to be talking about the COVID-19 vaccine claim scheme. This is a relatively new development that isn't workers' compensation related, but will probably have a flow-on effect to workers' compensation in the event that someone wants to claim compensation for a vaccine claim but doesn't want to lodge a workers' comp claim specifically. So the Australian government is currently developing a specific claim scheme for people who suffer moderate to significant side effect due to an adverse reaction of a COVID-19 vaccine. It's still being developed, still quite raw and new, but essentially they can claim compensation in the event that this occurs. It's a little confusing, but essentially the scheme will cover the cost of injuries for a minimum of $5,000, up to about $20,000 at this stage. And if something is going to be costing beyond $20,000, including matters of death, then this is still being developed and we don't have any information at all. But between $5,000 and $20,000, as long as there's an adverse reaction and the person's been hospitalised and they can provide evidence of a few different indicators, they can or will be able to claim compensation through this scheme. The type of evidence they're going to have to provide, so the nature of the injury and the medical documentation relating to the actual vaccine and the adverse reaction, anything hospitalisation related, and information regarding lost wages and medical costs. So as long as they have that information, they can prove that they've had an adverse reaction to the COVID vaccine, then they're going to be eligible through this scheme, which would be quite good for workers' compensation as it will ease the burden on the amount of claims that will be coming through. Just a couple of minor things as well when it comes to COVID-19 and workers' compensation. In terms of travelling, if a worker catches COVID-19 whilst travelling for work, such as going to a business meeting, then usually this is covered and is compensable under workers' compensation, whether the work has a non-COVID-19 related claim or a COVID-19 related claim. In the event they're travelling to and from work, this is generally considered a journey claim. And in some states, these type of claims are covered, whilst in other states they're not. So as a general rule, if they're travelling for work and they contract COVID-19, it's going to be covered. If it's a journey claim, they'll just check your specific state, as some cover journey claims and others don't. In terms of working from home, again, this will be covered under workers' compensation, considering home will be considered their place of employment. So even though they're not contracted COVID-19 within the factory or the office itself, is they're working from home and they're working within core hours as throughout the course of employment, then they will be considered to be compensable when it comes to workers' compensation. It's going to be quite hard for someone to catch COVID-19 at home, considering they are isolated to a large extent. But in the event there's some type of transmission that is work-related, then the place of employment will be home and the claim will be accepted. Contract workers, in the event if you've got a contract worker who contracts COVID-19, even though they're not technically an employee of the company, a lot of time they will be deemed workers under the relevant state acts, which means if they contract COVID-19 that they are eligible to lodge a claim against your policy. Generally, regulators define deemed workers as someone who's working under a contract of service. So if you've got someone working under a contract of service and they're predominantly working with your workplace, then they will be able to claim COVID-19 claim. And lastly, just some key stats from Safe Work Australia. Would have liked something a bit more recent, but they haven't come out the 2021 stats obviously yet, considering the year hasn't passed. But just upon reflection, if you look at 2020, these are the key stats that come out of Safe Work Australia nationally. We've had about a bit over 1,200 claims lodged for workers' compensation under COVID-19 in that year. Of those 1,200 claims, 974 were accepted and 127 were rejected. The majority of those claims were directly linked to the COVID-19 virus, where we did have some that were, I guess, sequelae of the virus itself. So we had 212 for mental health as a result of the virus, and 57 were for were related to testing or isolation requirements. Overall, 19% were mental health claims, and the breakdown of those claims throughout the country pretty much mirrored the populations in those states, apart from Victoria, which had by far the most, with 809. You had New South Wales, who accumulated a lot of claims, in Queensland, that pitted out towards the other states generally. As the new stats come out, I think it'll give us a bit more insight as to what type of havoc COVID-19 is causing on workers' compensation, considering there's a bit more activity in 2021, but for 2020, they were the key stats. But apart from that, that's about it from me. Thank you.
Thanks, Adrian and Megan. We'll just go on to the questions now. So we have a few questions here. If you have any further questions that you'd like to submit, just pop them in the Q&A section and we can read them out. So we'll kick off with the first question. If there are grey areas in a public health order, should an organisation develop a vaccine policy to clear it all up, including all staff? Megan, this might be for you.
Yeah, I'll answer that question. Yes, I mean, I think it's advisable. A lot of our public health orders in varying states are very selective in its application of how the order applies. So if the organisation is working and wants to work on a basis where you've got part public health order and part the organisation wishing to mandate it, I think it's important for us to review the two and have a policy that works in together. So whilst if it's a situation that you're looking at implementing a policy to give the public health order more weight, your policy isn't going to do that in effect. The only thing that will have the most weight is indeed a public health order. So yes, I believe every organisation, if you're looking at putting vaccinations in the workplace, there should be a workplace policy applicable for it, with or without a public health order.
Thanks, Megan. Next question. When an employee has been stood down, how do employees accrue annual leave, long service leave and personal leave when they are not actually working? This is a question for casual and permanent part-time employees.
Thanks, Britt. And what I might suggest is I'll take the question underneath that as well and roll that all into one answer. And that's if an employee has been stood down, how long is the employer required to keep them on their books before termination can be applied? So in regards to a stand down, it's not the same way as our operations under Section 524 of the Fair Work Act, which is where we have a stoppage of work. So the argument's been posed by employees that they are ready and willing to work. So therefore, it's the employer that's preventing the employee from working. So therefore, the provisions of Section 524 should apply. But in effect, it's the employee that cannot, in that circumstance, meet the inherent requirements of the role to undertake their work. So the application of accrual of leave purposes for that time wouldn't be applicable the same way if there was a stoppage of work. So if there was a COVID outbreak in the workplace which required the organisation to stop, then yes, employees would accrue a leave for that time because there is the provision under Section 524 that an employee, if the organisation is shut down, then they must accrue leave. But under that provision, the organisation is also not required to pay the employee any accrued leave entitlements under Section 524. So it's merely the offer to the employee if they want to access their leave entitlements for such time as them not being able to meet the inherent requirements of the role, and for how long that goes for is really up to the organisation in its sense. There's a couple of things that the organisation would need to look at in regards to going straight to termination versus allowing the employee to go on leave for a little bit. And it's in regards to that, the Good Life Early case. I mean, the employee was stood down in April and wasn't terminated till August. So that's really giving the employee enough time to make informed consent about their vaccination status. So you could say, you can access your leave for a month and then we'll review it. And then following that, failure to get vaccinated can lead to the termination of your employment through a disciplinary process. So there's no benchmark of time, but giving the employees access to their accrued leave entitlements gives them that time to think about what they want to do, take into consideration the complexities on their financial circumstances if they are terminated on the basis of vaccination.
Thanks, Megan. And another question from Julie. I'm concerned if we can't keep the vaccination certificates in the event of an investigation, how can the organisation prove they have cited the certificate?
Yeah, I'm happy to answer that one as well. So there's two areas that this comes down to. So in regards to proof of vaccination, that is either directed under a public health order, how that information must be collected and maintained. Proof of vaccination should really only be used to basically prove that the person, visitor, employee is indeed vaccinated. So the Office of the Australian Information Commissioner has released instructions to organisations on how they maintain that information. holding of a vaccination certificate in itself is a medical record. Organisations, if they hold on to that information, must have consent from that employee on how the information is going to be held, how it's going to be stored, how long it's going to be stored for, who has access to that information, if there's any other third parties. So in the verses of just citing it, the office has also given advice there that citing of a vaccination record is enough to satisfy the requirements of proving a person's vaccination status without having to hold that certificate in its capacity. So what I would suggest is having a read through the Information as Commissioner's statement in regards to that information, because it holds some fantastic requirements under the Privacy Act that organisations must comply with, that you are taking on board if you're looking to retain the medical, the vaccination record on the basis of just merely citing it, because it should really be there just to verify vaccination status, unless it is governed under a public health order, that you can hold on, maintain and keep that vaccination record.
Thanks, Megan. Now we have one more question here. Is it reasonable for a worker in an organisation under a public health order to expect to be able to work from home ongoing as part of their condition of employment, even if it doesn't work ongoing for the organisation?
Yeah, I can answer that one. A condition of employment would say to me that that is under their contract of employment. So if their contract of employment states that they work from home, yes, they would continue to work from home. But if their contract of employment doesn't actually state that they work from home and that they work from X workplace or over multiple sites, then the condition of their employment is that they do work from those places. Now, that's going into the discussion of returning your staff to the physical workplace and the requirement to be vaccinated. So working from home is not a workplace right. Importantly, it's not a workplace right unless you meet the requirements under Section 65 of the Fair Work Act, which is where an employee can legally request a flexible work arrangement, which can include working from home. But in itself, in its entirety, employees that work from home don't have a right to work from home unless their contract of employment purely is working from home. So if you want your employees to return to work, if the work cannot be done from home, you need to look at the public health order in place. If your public health order in place allows your staff to be in an office, I'm pretty sure all states now allow the return to work, along with Victoria as well, then an organisation can make reasonable adjustments with consultation to return staff back to the office. And then if they cannot because of their vaccination status, then we're looking at standing down the employees. But that would require consultation with our current staff and risk assessments of returning back to the workplace and all of our occupational health and safety requirements.
Thanks, Megan. Well, that concludes all of the questions that we had sent through. So we might close this session for today. So I'd just like to say thank you to Adrian, thank you to Megan. I'm sure that was extremely informative for our members. To our members, we'll be sending out an email with the recording and some contact details as well if you'd like to get in touch with either Adrian or Megan after this session. So thank you, everyone, and enjoy the rest of your afternoon.
Bye.